Question: which of the following was not a characteristic of the Munda administrative system? Oral tradition, community enforcement, codified penal laws, customary dispute resolution. Codified penal laws. Recent judicial discussion in Jharkhand emphasized the legal validity of these traditional systems. For instance, the Wilkinson Rule of 1837 recognized the customary practices in the Kulan region. In the officially exempting from the standard Indian Penal Code and the Code of Civil Procedure to preserve tribal autonomy. The Munda administration system, known as Munda Manki system, is defined as a traditional non-statutory form of self-governance, non-codified nature. Unlike modern legal system, the Munda system operated without written or codified penal laws. Instead, justice was administered based on long-standing social custom, collective wisdom, and unwritten ethical codes. Customary justice penalties were not standardized in books but were decided by the Gram Sabha or Pada Panchayat based on the gravity of the offense against the community's moral fabric. Community enforcement. The community acted as the primary enforcer. Decisions made by Munda village head or Manki regional head were collectively upheld by the villagers through social pressure or ostracisms, with high in extreme cases in relative tribes. Customary dispute resolution. The system relied entirely on customary laws to resolve conflicts regarding land, court riots, marriage, and social conducts. Which of the following conditions should be met for political party to be recognized as national party? The party should be recognized at least in four states as a state political party. Party that secures at least 6% of the total votes in Lok Sabha elections or assembly election in four states and wins at least four seats in the Lok Sabha is recognized as a national party. It is recognized as a state party in at least four states. Therefore, six regional national parties in the countries are like BSP, BJP, Communist Party of India, CPIM, Marxist, Indian National Congress, National People Party. The disqualification of the membership of state legislature is laid down in which article of the Indian Constitution? Article 191. A person is ineligible to be elected to and serve in the Legislative Assembly or Legislative Council. Person occupies a paid position with the Government of India or the government of one of the states listed in first schedule, excluding a position in the state legislature from disqualification. If a court competent jurisdiction has determined that he is mentally ill, if the insolvent is at and released, if the person is not an Indian citizen, has chosen to become citizen of another country or has pledged their loyalty to another country. Article 190 states that no one may serve in both cases. Houses of the legislature of a state and the legislature of a state shall provide by law for the vacation of any person elected to serve in both houses to travel home or to another location. Article 144 is the Indian Constitution. Article 144 instructs civil and judicial agencies to support the Supreme Court in its work. It states that Supreme Court shall get assistance from all civil and judicial bodies within the boundaries of India. Article 14. Within the boundaries of India, state may not exclude anyone from enjoying equality before the law or equal protection of the law because of this religion, race, caste, sex, or place of birth. A person shall not be disqualified for being chosen as a member of municipality at the age of 21 years. Article 243(5) Part 5 of the Indian Constitution provides for disqualification of memberships. It includes that no person shall be disqualified on the ground that he is less than 25 years of age if he has attained the age of 21 years. The Constitution 74th Amendment Act 1992 introduced Part 9A in the Constitution, which deals with the municipalities in an Article 243p to 243ZG. It has given constitutional status to municipalities and brought them under the justiciable parts of the Constitution. All the members of municipalities are to be directly elected by the people of the municipal area. And for the purpose of making it the electorate, the municipal area is divided into terrestrial constituencies known as wards. Besides the seats filled by direct election, some seats may be filled by nomination of persons having special knowledge and experience in municipal administration. The principle of social justice incorporated in the DPSC are influenced by which philosophy? Gandhiism. Gandhiism is a socio-economic political philosophy inspired by thoughts and principles of Mahatma Gandhi. The principle of social justice incorporated in the directive principle of state policy in Indian Constitution are directly influenced by Gandhian ideals. It emphasized the upliftment of marginalized sections of society, including the poor, the downtrodden, and rural population. The Gandhian principle in the DPSP directive principle include the promotion of cottage industry, organization of village panchayat, and provision of free and compulsory education to children. The Gandhi advocated for a society based on nonviolence, ahimsa, self-reliance, Swadeshi, and decentralized administration. Some of these ideals are reflected in the directive principles such as Article 40, Organization of Village Panchayats, and Article 43, Promotion of Cottage Industry. By incorporating these principles, the Indian Constitution aims to create an equitable and justice society which is in the cornerstone of Gandhi vision for India. Capitalism is an economic system based on private and they are not fit for profit. Capitalism is an ecosystem based on privacy of the means of production and their operation for profit. It emphasizes the role of market and competition in economic decision making. The principles of capitalism are not aligned with the social justice ideals of the DPS directive principles which emphasize welfare and equality. Anarchism is a political philosophy that advocates for the absence of formal government or authority. It promotes the idea of stateless society which is contrary to the principles of directive principles that envision a strong state's role in achieving social and economic justice. Communism Communism is a socio-economic ideology advocating for classless society where the owned. While communism and socialism influence certain aspects of directive principle, the core philosophy aligns more closely with the Gandhi, which emphasized non-violence and decentralization. Question 4. Which of the following is not correctly matched? Article 22.4 by no law providing for the preventive detention authorized detention of Yes, 22.2 Parliament may be the prescribed that certain which a person may be detained for corporate laws. 22.1 No person who is arrested shall be in custody with challenging. 22 right to be defended by legal protection for his or choice. 22.2 Parliament may by the law prescribe the circumstances under which a person may be detained for a period longer than 3 months. Article 22 of the Indian Constitution provides safeguards against the misuse of police powers to make arrest and detention. Article 22, subclause 1. No person who is arrested shall be detained in custody without being informed as soon as may be of the ground for such arrest, nor shall be denied the right to consult and to be defended by a legal practitioner of his choice. By subclause 2, every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest. Article by subclause 4, no law providing for preventive detention shall authorize the detention for person for a longer period than 3 months. Consider the policy statement regarding the President rule under Article 357. The President takes over the administration of a state in case in constitutional machinery breakdown. The President's action during a state emergency cannot be challenged in a court of law. Constitution 7. Consider the following statement regarding the president rule under Article 356. The one is only correct, दूसरा is wrong. Declaration of reasonable nexus, Supreme Court. Article 356 of the Constitution of India deals in case of failure of constitutional machinery in states. Article 356 of the Constitution of India deals with the provision in case of failure of constitutional machinery in states. India borrowed this provision from Section 93 of the Government of India Act 1935. According to Article 356 of Indian Constitution, the President of India has the authority to impose President rule against the state, nation and suspend state government. If he is satisfied that situation has arisen in which government of the state cannot be carried in accordance with the provision of the Constitution. Constitutional basis for the President rule. Article 355. It shall be the duty of the Union to protect every state against external aggressions and internal disturbances and to ensure that government of every state is carried on in accordance with the provision of the Constitution. 355. It shall be the duty of the Union to protect every state against external aggression and internal disturbance and to ensure the government of every state is carried. It is a violation of Article 355 by that state. And the President may impose Article 356 of that state and assume his rule. There are some conditions that President has to consider before. If the President is satisfied that a situation has arisen in which the government of the states cannot be carried on in accordance with the provision of the Constitution. If the President is satisfied that a situation is arisen in which the government of the state cannot be carried on according to the provision of the Constitution, the state government is unable to elect a leader as a chief minister within a time prescribed by the government of the state. There is a breakdown of coalition leading to chief minister having a majority in the House who a majority in the given period, loss of majority in the Assembly due to vote of no confidence in the House. Election postponed on account of situations like natural disaster, war, or epidemics. The states of the procedure that are followed in the imposition of the President rule in a state. First, the violation of Article 10 of President has to be proven for imposition of President rule in a state. Such a violation situation has to be looked into and the President has to be satisfied that invoking Article 10 upon is expedient. The President, when satisfied, proclaims a state emergency. Such a proclamation to be implemented has to be approved by the Parliament of India. It has to be approved by both the houses of Parliament within 2 months of issuance by the simple majority. In case the Lok Sabha is not in session or it is dissolved, and the proclamation is approved by the Rajya Sabha, the proclamation continues till 30 days from the constitution of the Lok Sabha. When the proclamation is approved by the Parliament, it can remain active for 6 months. This period can further extended up to 3 years in a phases of 6 months when approval has to be obtained from Parliament in every phase. When the proclamation is approved, the Parliament can remain active for 6 months. The period can further extend up to 3 years in phases of 6 months, which approval has to be obtained from the Parliament in every phase. The 3 year extension limit was introduced through the 44th Constitutional Amendment. Such an extension has to be backed by strong reasoning and justification before the 44th Constitutional Amendment Act. The maximum period up to which the President rule can be imposed was for 1 year. Duration of the President rule per proclamation of President rule under Article Constitution of the Constitution stands for 6 months. The time frame can be extended up to 3 years in phases. President rule can be revoked at any time by the President and this does not require Parliament's approval. According to 44th Constitutional Amendment Act of 1977, the President's rule can only be extended over a year of 6 months under the following conditions. The Election Commission certifies that elections cannot be conducted in the state concerned. There is already a national emergency throughout India or in the whole or any part of the state. The action of the President during the substance of state emergency were open to judicial scrutiny, says the Supreme Court in recent ruling. Union Public Service Commission may agree to serve the needs of the state on request of the governor with approval of President. Union Public Service Commission may agree to serve the needs of the state on the request of the governor with approval of the President. Article 315 of the Indian Constitution provides for the Public Service Commission for the Union and for the states. It explicitly states that Public Service Commission for Union, if requested so to do by governor state, may with approval of President agree to serve all or any of the needs of the state. As per Article 312 of the Indian Constitution, the Parliament is entitled to create one or more All India services, including an All India Judicial Service common to the Union and the states. The recruitment to all these services is made by the Union Public Service Commission, which is an independent constitutional body. The provision regarding the composition of JPSC, appointment and removal of its members, and the power of function of JPSC are provided in Part 14 of the Indian Constitution and Article 315 to Article 323. The TRIPED came into existence in 1987. It is a national level apex organization functioning under the Institute to Control Ministry of Tribal Affairs. Tribal Cooperative Marketing Development Federation of India (TRIPED). The Tribal Cooperative Marketing Development Federation of India came into existence in 1987. It is a national level apex organization functioning under the Institute to Control of Ministry of Tribal Affairs. TRIPED has its head office located in New Delhi and has a network of 30 regional offices located at various places in the country. The ultimate objective of TRIPED is the socio-economic development of tribal people in the country by way of marketing development of the tribal products such as metal craft, tribal textiles, pottery, tribal paintings, and pottery on which the tribal depend heavily for major portion of their income. National Commission for Scheduled Tribes. The National Commission for Scheduled Tribes is also a constitutional body in the sense that it directly established by Article 330A of the Constitution. It was created by passing the 89th Constitutional Amendment Act 2003. Ministry of Home Affairs, Minority Affairs. The Ministry of Minority Affairs is the Ministry of Government of India, which was carved out of Ministry of Social Justice and Empowerment and created on 24 January 2004. It is the apex body for the central government regulatory and development programs for the minority religious communities in India. Minority of Commerce and Industry. The Ministry of Commerce and Industry administers two departments: Department of Commerce and Department of Commerce and Industry. The head of the Ministry and rank. According to Article 6, the states are promoted especially economic interest of weaker section, particularly scheduled caste and scheduled tribe. Article 6 of the Indian Constitution is a direct principle of state policy. It directs the states to promote the educational and economic interest of the weaker section of the population, especially scheduled castes and scheduled tribes. The article emphasizes the need to protect these sections from social injustice and form of exploitation. This provision reflects the commitment of social justice and inclusive growth in the country. The inclusion of this article was inspired by the need to address the historical socio-economic disadvantage faced by the scheduled castes and scheduled tribes among the most marginalized community in India. The state uses various programs, policies, and schemes to fulfill the obligation laid out under Article 6, such as scholarship, reservation, welfare schemes, and economic support programs. This article is part of the broader vision of the Directive of State Policy, which aims to establish a welfare state in India. Urban population. The term urban population refers to people living in cities or towns which are characterized by high population density and infrastructure development. While urban areas are important for economic growth, Article 6 is supposed to focus on weaker section, particularly scheduled castes and scheduled tribes, and not urban population as a whole. Although the Constitution ensures the right and welfare of all citizens, Article shall specifically focus on the weaker section of the society, especially SC and STs, to provide them with additional support. While women, especially from marginalized community, are included in welfare measures, Article shall is not limited to the promotion of the interest of women alone. It focuses on the broader category of weaker section, including both men and women for a scheduled caste.